the United States is party to a treaty called the International Covenant on Civil and Political Rights that prohibits discrimination on the basis of race, among other things. But I'm not going to focus on that treaty because there's a treaty that's much more detailed about women's rights, which the United States has not ratified. And that's the Convention for the Elimination of Discrimination Against Women. This treaty was adopted in 1979 by the UN General Assembly, and it entered into force on September 3rd, 1981, after the 20th ratification by a country. And that means the 20th country that became a party to it. This treaty reaffirms the dignity and worth of a human person. It prohibits discrimination on the basis of sex with respect to civil and political rights and economic and social and cultural rights. So it covers the whole spectrum of rights. It requires states to take appropriate measures, including legislation, to advance the rights of women and under the treaty. The US signed this treaty in 1980, 17th of July, 1980. Palau is also a signatory to this treaty that hasn't ratified it, but the US has not adopted it as the supreme law of the land, and I will talk about later why that would make a difference. There's only 6 other countries that have taken no action with respect to this treaty, and those are Sudan, Somalia, Iran, the Holy See, Niue, and Tonga. All the other countries in the world are parties to this treaty, adopting the rights of women to be on equal terms with men and adopting this and talking about the specific rights that women have. Let me just briefly go through what some of the provisions of this particular treaty do that are beyond just prohibiting discrimination against women. First, it affirms the right to reproductive choice. The second, it's the only international human rights treaty from the UN that mentions family planning in Article 12. The preamble of the treaty also mentions the need for change in the view of stereotypes of the role of men and women. So it specifically understands that there's stereotypes that need to be addressed and requests and countries are committed to addressing those stereotypes. The committee that oversees this particular treaty is made up of member countries, and it oversees the compliance of other countries with respect to that treaty. So there's usually a rotating group of countries that are elected to oversee that particular treaty. So why would it matter if the US was a party to this treaty? First of all, the treaties, if ratified, are the supreme law of the land and under the Constitution. So it would be the overseeing law of in the United States that would have set forth these particular rights for women. One of the things that would have to be addressed is that the United States, up till the present, has been ratifying human rights treaties with what are called a non-self-executing declaration, which makes it difficult to go directly to court to ratify, to enforce the particular treaty. But it's difficult to know whether it would be able to overcome, or advocates would be able to overcome that inclination of our senators to attach that declaration to the treaties. But even if it were attached, which I would strongly urge whoever's working on this to say, no, you should not attach this declaration, it still is a supreme law of the land, and it would help to argue before state and federal courts regarding and legislative advocacy and I would also add administrative hearings, because that is another place where women are advocating for their rights. That it is the supreme law of the land, and that the person making the decision should try to adopt the, or look at the treaty and make it, and consider it in making their decision. So it would make a difference, and certainly it would make an even more difference if it was adopted without the non-self-executing declaration. But I think that this is an important project that groups can work on and try to advance the rights of women in the United States.
Thanks so much, Connie. So I just have a quick question. Have you seen the use of CEDAW in arguments before courts in the United States, even though it hasn't been ratified?
I can't say that I have seen, it doesn't seen courts refer to it, doesn't mean that they haven't. And there's always courts, especially, you know, in jurisdictions all over the country that might have somebody telling them about it, and they might, and it's perfectly fine for them to refer to it, even if we're not a party to the treaty. I think it's really important to stress to the courts that all countries except for the 6 that I just mentioned are parties to this treaty, and could be argued to be that this has now become customary international law. So I still would urge advocates to bring it up as much as possible, and the more it is brought up, the more the courts are educated about that particular law.